Hi, good morning to one and all. We had started lesson 15 from the new syllabus, your intellectual property laws. Half chapter we had done yesterday, and half chapter today we will do it completely today, so that you are just left with the balance amount of chapters. For the old syllabus students, obviously this is not there in that much detail. So if you just got the basics right, or you can watch it up from our earlier marathons, you will still be good. Okay, since in the earlier in the old syllabus there's only one small chapter on it. Okay, so you can watch it from our earlier marathons. It's more than enough. Nothing else will come beyond that. Okay, so before I start, I need your confirmation from you all whether I'm audible and visible, so we can quickly start. Okay, just need a small confirmation. So I will continue from where I had left yesterday. Okay, and we will complete the entire topic. So we had ended out here the scope of intellectual property law. Clear? I need a confirmation from you all if I'm audible and visible, and we can start. Okay. Okay, great. Thank you so much for confirming, Sona, Siddharth. Let's start. So we had done one second. Just get myself. Yeah. So we had done the basics of intellectual property law. That is, intellectual property is creation of the minds, which is nothing but your trademarks, copyrights, patents, industrial designs, and GI marks. All of these will come in detailed chapters later on, but getting a simple idea is the objective of this lesson. Now, we have to understand, before we get into the Indian laws of intellectual property laws, how did the Indian law, how did they get their roots? From where did they originate? So we will have to understand the global impact first, because globally there was bigger impact, the initial impact of trademark, copyright and intellectual property law, after which it came into India. So we have to understand what is the World Trade Organization, what is their roles in intellectual property law, what is the GATS, TRIPS and WIPO, etc. kind international agreements. So generally we understand that WTO covered goods, services and intellectual property. It came into force on 1st Jan 1995. Okay, and GATT mainly covered only goods, GATS covered services, and TRIPS covered enforcement of law, dispute related aspects, covering all the intellectual property laws. So before I get into the Indian laws, we are going to talk about the international treaties and international organizations. So let's go into the depth of each of them. First, we have to understand the difference between GATS and TRIPS. So first is what is GATT, second what is GATS, and what is TRIP. So first let's get into the history of it. We have to understand that all the intellectual property laws and their global impact started to come after the World War II ended. Now the World War II ended on 2nd September 1945. Now imagine, moment the World War ended, there was lot of hostility, enmity, kind of resentment to trade between nations. Because there was a world war, there was lot of entry barriers into other countries. There was lot of trade restrictions. There was lot of we versus them scenario. Foreigners were treated differently as compared to Indian laws, and there were global barriers. To do away with this and to simplify international trade, to make international trade, global trade possible, we had the very first treaty, and that was GATT. So immediately after the First World War, the treaty that was made to promote or boost international trade was General Agreement on Tariffs and Trade. It covered only goods. So let's see. The General Agreement on Tariffs and Trade was a multilateral agreement. So when I say multilateral, means multiple countries had signed this. It was approximately 123 countries who signed the GATS in Geneva in 1945. So in 1945 the World War ended, and in 1947 the GATT was introduced. Okay, then after GATT, so GATT was there for multiple years, approximately 40-50 years it was in place, until another agreement between 123 nations on Marrakesh on 1st April 14, 1994 in the Uruguay Round Agreement. The WTO was established on 1st Jan 1995. So after GATT, WTO came into force. So GATT was completely abolished by the WTO. Now let's understand what is the WTO. We saw that its existence came into 1st Jan 1995. What was the role with respect to intellectual property law in the WTO? Now, the WTO is nothing but a multilateral organization where we have countries all over the world. That is 123 countries had signed this agreement. On 1st Jan 1995 it commenced under the Marrakesh Agreement. It replaced the GATT, and WTO is there today, that is applicable on all of us, which regulates, it makes policies, governs international trade. Okay, it regulates trade between various countries, and also if there is a dispute, how do you set dispute settlement or dispute resolution process has been provided under the WTO. Then what is GATS? Now again, we have understood the GATT, we have understood the WTO which repealed the GATT. Now comes GATS, that is General Agreement of Trade in Services. So this is specifically concerned with services. Now this was also a part of WTO agreement. Okay, so it came into force along with your WTO in 1995 and was a part of the WTO agreements. What did it talk about? That there should be services should also be traded, should be across countries, services should be provided. So earlier GATT was only concerned with goods, but WTO is covered not only with goods but also services. So in WTO there is GATS which specifically covers services, which was not there earlier. This was same negotiated in the Uruguay round. It lays down the same discipline, rules, dispute settlement, but with respect to international trade in services. So we know today services can be provided. We can take services of like for example our classes as well. We have taken Amazon Web Server Services. This provides us where the data can be stored on cloud. So all of this, what are we doing? We are taking international services. Second, for you all must be watching Netflix. You all are taking international services. Same way, so nations can now provide services easily, just like goods were traded earlier. Now, let's see about GATS in a little detail. Now, first thing we know that GATS is a agreement. It's a general agreement between the countries to deal in services globally. So the is the first ever collection of legally binding multilateral regulations governing trade in services. Simple line is, it is the first. I told you before this there was nothing about services. So it is the first ever legally binding. So countries, when they sign the GATS, they are legally bounded, and this is not just one country, all multilateral, multiple countries are bound, stating and governing by the rules of GATS, saying that they can globally trade in services. Next, it was negotiated in the Uruguay round and came into effect just as WTO came into effect. A part of WTO is GATS, which spoke about services. Is a treaty of the WTO entered into force in 1995. Now, what does the GATS talk about? Okay, very important. Let's understand that just like for goods, the same rules are there for services. What all would they normally say? So the first thing is they talk about certain principles or certain kind of philosophies while dealing in global trade. That listen, if you see, it's the United Nations and the WTO wanted that the national barriers are removed and people can easily trade in goods and services. So when will they be free trade? When will this free trade be allowed? Think. When will free trade? Now when I say free trade means what? There are no barriers, unnecessary barriers. Putting a custom duty is not a barrier. Disallowing someone is a barrier. Okay. Then they have said that we should have your cross-border goods and services. So that also was allowed, that cross-border goods and services here specifically for services has been allowed. Next, they have said that listen, don't do we versus them. Don't give preferential treatment to your insiders, and outside countries should not be treated separately. So they have put that national treatment should be given even to outsiders. That means if today a person from USA is selling their goods here, India should not say that listen, this is from USA, this is from India, take only Indian goods. This kind of activity should not be done, is what GATS has told. Because they want that barrier should be removed. So it's just like one and the same, give them equal treatment. Then only trade will prosper. Otherwise, there will always be reciprocity. That is, reciprocity means what? If they have done like this, then we will also do like this, and this doesn't give a good kind of trade environment. So again, let's see. First, GATS says that all services are covered. It covers international payments. Then regulation should be reasonable. If we have put custom duty, it should be fair. Transparency should be there in the regulation. So any country dealing with any other country should know that these are the terms and conditions to deal in services. Now there are three important lines. Okay, three important lines. Most favored nation treatment. That means if you are giving, now it sounds that simply in simple language it means that don't favor any country. Don't give preferential treatment to one country and not preferential treatment to the other countries. So if you have favored one, then favor all is what the principle says. That's how they have worded it. That most favored nation treatment applies to all services. That if you favor one country, then you should go ahead and favor all the countries. This is one technical term that you can write. Next, principle of national treatment. Now, as I told you that we should treat everyone as we would treat our citizens. Okay, treating foreign goods as the local goods. Now, obviously, countries do not freely follow this, but GATS principles is this. Progressive liberalization. Liberalization means to make laws simplified, removing the barriers, simplifying the procedures, making faster, transaction time is what is there. Okay, so we've understood what does GATS generally talk about. GAT, goods, service will have the same rules. Now, general agreement on tariffs and trade. Remember, we said that this was immediately after the end of the Second World War. When the World War ended in 1945, the first organization that was created was GATT. And this covered about goods only. Goods only. And general agreement, GATT, the GATT's counterpart in goods and services. See, as GATT's gave goods and services, GATT's provided services, but they all had the same goals. The goals were the same. Now, what kind of goals would they keep? Think. After the World War, now we are seeing of GATT's, okay, the first organization. Imagine a World War has just occurred. No country is talking with any other country. The allies are not talking with the Axis powers when we had seen whoever are there. So how do you try to say? They say, listen, whatever is done, now we have to boost the economy. Now we have to boost the economy. So to boost the economy, we have to liberalize things. But obviously we know that after a war, things will not just open up. It will progressively, slowly, day by day, it will liberalize and be simplified. Then once it is simplified, we have to say now stop discriminating, think everyone is same. So they are saying guarantee non-discrimination to everyone, then only trade will happen and then only economic situation will improve. And with time, trust and reliable systems will be developed, and that is what is the main goals of GATT. Now GATT functioned on 3 levels. Now it's very simple, see, okay. On 3 levels it functioned. GATT first gave the first part, gave about the basic principles. We saw what was the basic principles of GATT. The same is for GATT also. We saw most favored nation clause, national treatment, progressive liberalization. These are all principles which is same for GATT and GATT. It functioned on 3 levels. Okay. Basic principles, the second gave you the rules, and third gave you commitment, nation's commitment. Each nation committing that, listen, we will allow our market to all countries. So the functioning focused on 3 levels, the principles, then making your detailed rules for each sector, and then nation commitments to allow access in all countries. In contrast to goods, GATT had one more point. GATT, the General Agreement on Trade and Services, had one special 4th element. It spoke about the most favored nation clause of non-discrimination, which was not there earlier in GATT. So GATT provided a 4th special element, that is a MFN clause. The MFN clause. MFN clause says if you favor one country, then it is your duty to favor all countries. Then comes the goods versus the service sector. I want to know from your perspective, what is more? The service sector is more or the goods sector is more? What is done more in India or globally? What do you think? More amount of services are being provided or more amount of goods are being provided? So the answer is obviously everybody majorly provides services. So services today make up 2/3 of the global production and employment. So employment is provided majorly by service sector. However, tell me one thing, the big amount of revenue, the big amount of GDP is generated from goods or services? Obviously, when we see manufacturing units, when they are selling one product might go for 1 crore, 9 crores, 15 crores, big industrial equipments. So those services help in more employment, but GDP is what now they will talk about. But services, though they take up 2/3 of the employment and they provide the employment, However, with respect to payments, they only generate up to 25% of the total businesses. So out of the total revenue when we see the money aspect, services you don't earn much. But now this we are seeing last time, okay? Now what are we saying, that from here 25% share comes from services in revenue. So the balance 75% is coming from the manufacturing sector. So though less sales, though less employment, but the revenue and the GDP is more. So it is similar that Apple is really selling less number of phones as compared to the Chinese competitors. But the profit, the net worth of Apple is much higher as compared to the other competitors. So it is about operating with high value. Okay, so we are saying, however, we have to see that even in manufacturing, service is used. So if we combine it, approximately 50% of the total commerce comes from services and 50% comes from manufacturing sector. Clear? So what have they first said, that 25% only comes from the GDP PC is coming from the service sector. The employment is coming from 25% only from services. But if we go to see, the balance is coming from manufacturing. But in manufacturing also services are rendered and used. So therefore we can say that services bring up to 50%. Now, two key pillars that support the GATT's contribution to the global services are. Now, two key pillars that support the GATT's contribution to the global services trade. So what are two key pillars? Now see, if we just understand what does GATT's do, you will understand globally they are helping in predictability of the rules and regulations. So since they lay down the basic framework, the principles, we know that it will lead to increasing the openness and predictability of rules. That means I will know today the laws for USA, laws for any country in Europe will provide more or less the same custom rules, and which is a fact. Progressive liberalization. So again, GATT has helped not only increasing the predictability of rules. Predictability of rules means what I can assume that what will be the laws here. If every country started having a different law, it will become very difficult to do international trade. It's very important to have similar uniform rules, and GATT has also helped in progressive liberalization. Then coming to, they have also said that national treatment. So as we had done national treatment to foreign services. But they are saying that, listen, we are not saying it should be deregulated. Just because we are saying that there should be free trade, that doesn't mean that there should not be any law governing the procedural laws. That should be there. Only thing we are saying is do not do discrimination. So we are not saying to deregulate. Regulation should be there, but minimum regulation should be there. Then comes a small part which they are saying that in all these WTO agreements, we have always focused on building the underdeveloped and developing countries also. So how do you help aid the developing countries? So they say that, listen, no matter whatever framework we make, we should always provide support, access, necessary upliftment strategies for the developing countries as well. So the agreement's overall framework and specific sections were influenced by concerns for developing countries. So they felt a lot of concern, lot of feeling for developing countries, that they shouldn't be left behind in the global development. The preamble to the agreement are motivated by the goal of growing participation of developing countries. So they will also monitor and try to get participation from developing nations. Developing countries should get access to the information network, distribution network, any kind of capacity building tools that the developed countries has, it should be provided to the underdeveloped countries also. The fundamental principles of GATS is the idea of progressive liberalization. Progressive liberalization means slowly save time. Liberalization must place with due consideration for national policy objectives and development. Additionally, the WTO Secretary is permitted to provide a technical assistance to the developing countries. Again, the WTO Secretary is permitted to provide technical assistance to the developing countries as and when it is needed. So we saw GATS. Now we will see something called as WIPO, World Intellectual Property Organization. Now, as we saw that in all this, none of them spoke about intellectual property specifically, right or wrong? See, what did they spoke? They speak about goods and they spoke about services. Okay, and they did not specifically have anything for intangible or intellectual property, which is actually the topic of the day. That really comes up with the formation of the WIPO. WIPO specifically spoke about this. So let's see. Now the World Intellectual Property Organization, that is WIPO, is the United Nations agency. It is the most important organization for promotion of intellectual property. Till now there was nothing with respect to dedicated for intellectual property. WIPO is the first organization which came up for promotion of intellectual property. It was created in 1970 to encourage creativity, protection to intellectual property throughout the world. Its headquarters is in the beautiful Geneva in Switzerland. It ensures that the right of the creators and the owners are protected worldwide. So again, understand one thing, that moment they ask you in the exams about write a short note on the WIPO. So you should know that it must be of United Nations agency. So it is a United Nations agency, one. Second, it is concerned with intellectual property. So we will say it is talking about intangible assets. And third, when we are seeing it is world, that means we are saying that intellectual property should be protected, promoted and distributed throughout the world. Okay. So that is why it is intellectual property should be protected not only in your home country but any country in the world. So today if I have written a song, or I have sung a song, or I have written a script, I can apply for protection worldwide. So Apple gets a global patent. They don't only get a patent in USA, but we know that sitting in China there might be some person trying to do reverse engineering and try to copy their product. What is reverse engineering? Reverse engineering means what, they break down the product which is already made and try to figure out what was the technology and then develop their own. So this is called as reverse technology, which is done by China. Next is United Nations organization devoted to using intellectual property as a tool to foster innovation, creativity in the world. Correct? Because as we know that intellectual property, if rights have been given, if economic benefits are given to the creators, it will lead to development of creativity, boosting of creativity, fostering innovation, fostering creativity, as well as getting more revenue and recognition to the country. Following the WIPO convention entrance in 1967, WIPO was founded in 1970 with a mission for its members to advance intellectual property throughout the globe. Now, how would they do that? Obviously, this cannot happen unless there is intergovernmental cooperation. If imagine I have developed a particular technology, but Dubai is not giving me protection. So then you cannot get worldwide protection, right? So countries have to say, listen, that if there is any creator in your country and he is the original creator, we will protect him in our country as well. The goal is to foster innovation, creativity in creation of a fair and transparent intellectual property system for the benefit of all nations, economic, social and cultural development. In 1974, the organization was designated as a specialized agency of United Nations, we saw, to create open and fair worldwide intellectual property systems that encourages innovation, rewards creativity and advances economic growth. So this, we'll have to learn this sentence the way they have written, that it is creating fair and open worldwide intellectual property systems that encourages innovation, rewards creativity and advances economic growth. Next, by signing the cooperative agreement with the WTO, WIPO enlarged its mandate and further illustrated the significance of intellectual property in administration of trade. In order to establish and unify the laws for protection of intellectual property, WIPO serves as a platform for its member states. So what are they trying to say out here? They are trying to say that WIPO is coming to make uniform laws, uniform procedures, uniform protection strategies which will encourage creators and protect the creators and their creations. WIPO provides for global patent filing services. As I told you, that Apple gets global patent. It gets their products globally patented, so that if I am in India, I still can't use it. If you would be in Korea, even you in South Korea, you also won't be able to follow it. So in North Korea, it doesn't cooperate. So it's very difficult to protect intellectual property in that country. Systems of now again, whenever we talk about any international agency, they also think about the ones who are developing. How can they develop? What else support can they be given? Okay. WIPO plays a critical role in assisting the new systems. So again, WIPO will make in new systems, new techniques, and will promote them. Will ask the other countries to implement them in their country as well. The WIPO works to advance the growth and application of the global intellectual property by. Now again, how will WIPO advance the growth and application of intellectual property systems? So whatever system they are making, rules, guidelines, standard operating procedures, whatever WIPO is made, how will they do it? So first, by making the laws, okay, develop international legal IP frameworks and tell the countries to follow this. So the first, when we are talking of their system, what is their system talking about? So system is talking about a law. Then they are talking about infrastructure. Infrastructure, how do you apply? What is the application procedure? What is the fees? What will the country get if they are providing? So build cooperative networks and technical platforms, okay, including free database and tools for exchanging information. If one country, if there is a dispute, then we'll have to see who's the real creator. Exchange of information should be done from one country with the other. Development, building capacity in the use of IP to support economic development. Okay, so this is how WIPO is bringing growth in the global intellectual property system. Next is services. Run systems which make it easier to obtain protection internationally and resolve IP disputes. So again, growth will be in the services on getting the protection, as well as if there is a dispute, then to resolve the disputes. Now, they are saying legal frameworks under WIPO. There were various treaties made under this subdivision or this sub-organization of United Nations. There were multiple other treaties. Let's see, the first one and the important one is your Patent Cooperation Treaty. Now, patent is for inventions. If a product has been invented, then there is a procedure to get yourself to patent the product. When you provide for application to register your patent, we will see in the patent chapter how it is done, but you have to provide the full, there is an entire form in which you have to provide the technical data on how did you develop, what is the internal thing, because imagine making extremely technical softwares or making extremely technical products, their workings, then you have to tell exactly how did you make it. So the Paris Convention's Patent Cooperation Treaty, so this was in Paris, enables public access to a plethora of technical data. So to a wide range of technical data you get public access pertaining to such inventions, while also assisting application in securing patent protection for their ideas on global scale. Pertaining to such invention while also assisting application in securing patents on a global scale. So again, same point they will say, securing patents on a global scale and also getting access to technical data. So there is one thing that imagine if I have applied for a particular, let's say I have made a particular device. Now what will happen is I am applying for patent. The registrar of patents publishes this application, not the detailed specs, but they will publish it asking that this category is trying to be registered. There is another person who feels that they have really developed and is being copied. So they would want access and more details, and how do you dispute? So all of that is covered in your Patent Cooperation Treaty. Then going to Madrid. Okay. And also in this other thing, they are saying that in one application you can get a worldwide protection. So there is a one global patent that you can file, which will give you registration in multiple other countries. Now coming to Madrid Agreement. Now in Madrid was signed in 1891 and the protocol pertaining to that agreement was signed in 1989. So in 1918, approximately 34 years back, this was signed, set forth the rules for the Madrid system for the international registration of marks. So you can write this key word there, that is marks. Now they are saying there are different kinds of marks, that is trademarks, certification mark, group marks, service marks, sound marks. All of this that is there for international registration of that. By acquiring an international registration, now all of this is talking about international registration. It is valid of each specified contracting parties. The method enables the protection of a mark across a wide range of nations. So again, this is specifically talking about trademarks, marks, logos, etc. This in Madrid they were talking about marks, here they were talking in Paris, they were talking about patents and their global protection. Now coming to your Vienna Agreement. Vienna Agreement was also of the similar kind, but here they have given the classification for those marks. Classification of marks. So again, for marks that are composed of or incorporative figurative features, the Vienna Agreement creates, so what does it do? It creates an international classification of figurative marks known as Vienna classification. Now let's understand, there is a product coding system which classifies the marks as per their category. For example, you could have steel in one category, then you will have raw steel, then you will have steel mixed with XYZ, or you will have steel scrap. different subcategories will be given. So those classification system has been provided under the Vienna Agreement. Then Nice Agreement was also similar lines regarding the international classification of goods and services for registration of marks. The Nice Agreement came into force. This was more about figurative elements, and this was about classification of goods and services. Now, figurative elements could be some elements which are there, and this is with respect to ready-made goods, etc. So combined they could be made to protect your patents or your thing, okay, patents, your services, whichever you want. Then Locarno Agreement. The Locarno Agreement creates the Locarno classification, an international classification system for industrial designs. Now this is specifically for industrial designs. Okay, under the Designs Act, what are the designs which are protected will come under the Locarno Agreement, and these are classifications. So they will further classify if it is a architectural design, if it is a software design, if it is a textile design. So they will classify it as per that. Then comes the WIPO Copyright Treaty. Now WIPO Copyright Treaty, from the name, now we saw everything but only copyright was left. So this was a copyright treaty, very simple, similar lines, everything they will write, but it will protect the work of authors and the rights of the authors in the digital sphere. Treaty has two items must be covered by copyright protection, that is your computer programs and your collection of data and databases. So very simple, in the digital sphere, when we see that is your softwares, copyrights, software can be copyrighted, your website can be copyrighted, your database management systems, all related to computers and digital sphere, can be copyrighted. Then comes your phonograms treaty. Okay, WIPO performance and phonograms. Now phono means sound and gram means written symbol. So imagine if there is a tagline, okay, or there is singers. This specifically covers two categories of beneficiaries. Performers, actors, singers can get registered here under their performances treaty. So for example, if there is a performance of a particular singer, it cannot be broadcasted without his consent. It cannot be sold without his consent. And manufacturers of phonograms, persons or legal entities that take initiative, that have responsibility for fixation of sounds. So phonograms are those things which make sound. Okay, so all of that is covered. Now with respect to musical instruments, etc. Okay, which have sounds, especially music, understanding that whether two musics are similar, etc. WIPO Intergovernmental Committee. According to its mandate, WIPO Intergovernmental Committee on the Intellectual Property and Genetic Resources is engaging in text-based negotiation to find a text for a international legal instrument that will effectively protect traditional knowledge, expression and resources. Now this sounds extremely technical. What are they saying? That WIPO Intergovernmental Committee. Now what will the WIPO Internal Committee do? Internal Governmental Committee do? It's a committee, right? So committee's main job is to make policies, rules, guidelines, conventions, agreements, etc. They engage in negotiations, text-based negotiation. That means while developing the rules, they will have to negotiate, because let's say with respect to the climate change agreement, US did not sign because US said that I'm a developed country. This entire laws are against developed countries, helping only developing countries, and why should a developed country sign this? So there will be negotiations, okay, and from all of this to find a text for an international legal instrument. After negotiation, they have to make legal instruments. Now, when I say legal instruments, means what? Instrument here, they are talking about instruments for change. Instruments could be your laws, recommendation, declaration, your code of conducts, your laws, etc. So legal instruments. So through negotiation, they should come up with some rules that protect the creator's knowledge, the cultural expressions, okay, which he has, and the genetic resources. Then coming to your standing committee on copyrights and related rights. Now with respect to committee, they look into the issues of substantive laws or harmonization in area of copyright related to. So there are two kinds of laws. One is procedural laws, the other one is substantive laws. So the standing committee will look into the issues of whichever in laws, which all areas need to be amended, etc. Then the Hogg system says that, listen, we should have, if someone wants to file a patent, we require some kind of software, some kind of application where you can directly get protection in multiple countries. The concept was there, but we needed an application, we needed practically. So then that is in the Hogg system what was actually developed. So through the submission of a single international application, the Hogg system for international registration of industrial design, now this is with respect to designs, offers useful commercial option for registering up to 100 designs in 24 contracting parties spanning in 91 countries. So Hogg is a application, through a single application, the Hogg system for international registration of designs offers a commercial option for registering up to 100 designs in 91 countries and between lot of parties, 74 parties. So the toolkit is there. One international application, it will turn out cheaper, you get a global coverage, and it can have a centralized management. That is under the government, United Nations. Then comes your Lisbon System Agreement. By using a single, this is with respect to GI, just mark it as geographical indications. Now Lisbon Agreement, by using a single registration process and a single set of cost, it provides for registration and protection of GI marks. So GI marks are if a particular product is coming from a certain territory, a mark can be allocated, and that mark the producers or the developers of that area can use this mark. For example, your Ratnagiri mangoes, Alfonso mangoes, they put a special GI mark. They can get registered not only in India but all over the world through the Lisbon Agreement. All GI etc. will come when we do it. We have specific acts for it. Now next coming to Trade TRIPS Agreement. Now see, we saw everything in all these agreements. We saw protection was given under patents, trademarks, copyright, industrial designs, and GI mark. All we saw that there were some global initiatives to get. Mostly all of them said that there should be a single application, okay, which provides protection in multiple countries. Then they also say that, listen, if there is a dispute, that dispute should be settled. There should be rules, there should be predictability, there should be guidelines, etc. Now understanding TRIPS, then where does TRIP come into play? Okay, now understand, all the agreements we saw, they didn't have all in one, right? We had Patent Cooperation Treaty, We had something for GATS was for services. So we had everything separate. So now what happened is one law which spoke about not only industrial, all the laws and any disputes covered within. So TRIPS is really an umbrella for everyone. So if you go to see here, the types of, so it's a umbrella which covers all trademarks, copyrights, patent, designs and GI. It even covers other kinds of trade secrets as well. Trade secrets, we will see what it is, but every kind of intellectual property is covered. So intellectual property rights covered under the TRIPS. Copyright, trademark, GI, industrial designs, patents and trade secrets are all protected under the TRIPS agreement. Now what is the TRIPS? Let's see. So creators can be given a right to prevent others from using. So this is mostly about defending your rights or enforcing your rights if there is a violation. There are intellectual property rights. There are a number of forms that can come. All of them are protected here. Whenever there are trade related disputes, your protection is given under the TRIPS agreement. The TRIPS on the trade related aspects of intellectual property law is an international agreement administered by the WTO. Sets down, now what do? They put down the minimum standards that country must have for intellectual property protection. Means TRIPS is a country based or United Nation based? TRIPS agreement is a country based or United Nation based? Okay, so it is obviously a United Nations based. So what they will tell that, listen, they will tell other countries that, listen, we made the guidelines, you follow it. They will, what will they do? They will say that, listen, this is the minimum thing that we expect from you. So the minimum standards should be applied by the nations. Okay, it was negotiated, spoken, discussed in the Uruguay round in 1994. Beyond simply transporting items across borders, trade has developed to include value to bring its society. Now they are talking about IPR, what is the benefits, etc. So just a small read on it. Beyond simply transporting items. Now what they are saying is, normally in global trade, we used to believe that only goods were exchanged. But now it's not only goods, it's value. When we are talking of value, we are talking of service kind of things like IPR. I can give you technological support. I can give you technological know-how. Okay. So all of that also value is being provided. I can just tell you that use my mark. Imagine if one is allowed to use Tesla car logo. So value can be generated. So that's what they are saying, that beyond simply transporting items means goods across borders, trade has developed to include value to the societies. Today, international trade involves a significant amount of value exchanged through innovation, creativity and branding. So we saw that just by technological help, businesses value change, net worth change. Just by bringing creative aspects in a person's business, their value differs. Just by bringing innovations which the competitors are difficult to follow or difficult to implement, they can get a head start. So if you go to see, all the companies at the top keep innovating, launching new products to stay ahead of the game. Okay. So development of trade and policy state that knowledge-rich commodities and services can move across borders. TRIPS is an essential facilitating intellectual property trade, settling intellectual property disputes, giving the WTO members freedom to pursue their own national goals. So what they have done, by giving them the minimum thing, they said over and above what you want you do. So they are also giving them flexibility. Okay, freedom to pursue your own national goals also. So nobody follows 100% of the United laws. they tweak a little bit according to their national interest as well. The agreement formally acknowledges the importance of connections between intellectual property and trade. This was accomplished in the Uruguay round. TRIPS agreement is an attempt to put these rights under common international law and to close the gaps. So one is gap filling, wherever there is errors, wherever there is loopholes, to fill that, and how they are safeguarded and upheld globally. Minimum requirements for enforcement has been provided that each country should follow. WTO countries have a great deal of flexibility. Okay, as I told you, they can customize their IP protection laws. They can strike a balance between getting long-term advantages and cost of restricting access. Short-term cost of restricting access. So they can put, your GST kind of thing that we put whenever there's an import of technology, that is there. You can put a balance. Now, when I say balance means what? If I put too much custom duty, too much of GST, business will not flourish. So we will have to put restrictions, but not so much that discourage business. So they will have to see which is in the best interest of the nation. Through a variety of procedures permitted under the TRIPS, such as exclusion, members can lower the short-term cost. WTO's dispute resolution mechanism is accessible in case of trade disputes. Now again, if there is a dispute between two countries, two creators of two countries, obviously you need a neutral party to settle the dispute. So WTO dispute resolution mechanism is provided, you can go there. TRIPS agreement, okay. TRIPS agreement addresses 5 topics. Now again, what does TRIPS talk about? 5 things. What would they normally talk about? So they will talk about, first one, general rules for applying for intellectual protection. They will get the fundamental ideas. Okay. Next is minimum criteria, which I told you, which is needed. That beyond that, flexibility is given to the nations. Then they've also said that how do you settle the disputes, a dispute settlement procedures, mechanisms, etc. If dispute is there, they can go to the United Nations also, dispute settlement system. And special transitional arrangement. Transitional arrangement means what? If a country wants to slowly transit into the TRIPS agreement rules, regulation, they can do this. So how they can slowly transit, shift to the United Nations laws. And last is mechanism. What mechanism should members offer to defend those rights in their home countries? So again, how can a country, if there is any intellectual violation and from their citizens, how they can go ahead, or if there is in another country, how they can defend it? So how do you enforce your rights, basically what they are covering. So if we go to see, TRIPS agreements has 5 main topics: disputes, defending, minimum protection, general rules, and transitional agreements. Now we've seen the global aspects. Now we will see just an overview of all the intellectual properties that is there. So intellectual property, as we saw, is nothing but works produced by human intellect and mind. It refers to information that is used to create tangible goods simultaneously in an infinite number of copies at various locations throughout the globe. What does this mean? It means that the creator can make multiple products and sell it all over the world. At the same time, he gets a right to restrict, prevent others from using his product or logo. Now, very important is industrial property. Now, when I say industrial property means what? I told you in your property, in intellectual property laws, okay, in IPR, property is divided in 2 categories. One is your industrial property, and the other one is your non-industrial property. Now, industrial property is nothing but your trademarks, patents, GI and designs. In non-industrial property, you have copyrights, performers' rights, broadcasting, computer programs, everything coming here which is related to copyright. Clear? So when they write a short note on industrial property, you will mention that these are the industrial property, and since you will have detailed knowledge from after reading each of those chapters, you will be able to build it also. So industrial properties are those which go into manufacturing processes. For example, trademark, BMW logo will be manufactured. Your patents, it's an invention, it will be manufactured. GI mark. Okay. So designs also goes into manufacturing. All the others come here. Okay. The non-industrial is copyright, making a book, a performer's rights. A performer cannot be put into manufacturing process, right? So this is what is separated. Now coming to the industrial property, few points and we will be able to build it out. Now industrial property is sometimes misunderstood as relating to movable or immovable. Obviously we know that tangible and intangible is there. In intangible we have industrial property. Industrial property is a kind of intellectual property that is related to human mind. Inventions are new solution to technological problems. Industrial design, aesthetic creations includes trademarks, service mark, commercial marks, okay, indication of source of origin, that is a GI mark, etc. Industrial property may not appear entirely in the logical sense, or that the inventions are concerned with the industry. In other words, inventions are exploited in industrial plants, while trademarks, service marks are concerned with both commerce as well as industry. So they are saying it doesn't mean that everything has to be used in industry only. We have trademarks which are applied on products, so that is also fine. Okay. The Paris Convention recognized, so industrial property covers, as I told you, everything. It doesn't necessarily have to be used in industrial plants. Paris Convention has also recognized property to cover patents, trademark, service mark, trademark utility, industrial design, utility models, etc. Industrial property right is a collective name for the rights referring to commerce or industrial activities of a person. So again, they are repeating the same thing. They may be called as inventions, new products, new processes. Very important. In patents, invention could be a product patent or can be a process patent. Product patent is where you have made a product, iPhone, whereas processes can also be protected. For example, water purification process, how is you have made it. For example, how have you made a paint, how does the engine work, the process is also covered, or it could be both. A person's commercial or industrial activity are covered up by a group of rights known as industrial property rights. The action of commercial or industrial interests may be of those. They can be referred to as inventions, creation, new product, manufacturing methods, new designs, etc. So just a small few lines about it is absolutely fine. Now we will be talking about patents, trademarks, copyrights, industrial designs. All of this we have a chapter, so you don't have to dwell a lot on this. It will be covered in another chapters. So I will just explain the concept and move ahead here. Now patent is related, there will be a word called as inventions. Okay, here it is related to inventions. So whenever a person has made a new, novel, non-obvious invention, it will be patented. Now when I say patented means what? Patent is nothing but a right. to use the product and have monopoly rights over the product. You only have the right, you can ask anyone to use, or if anyone is using, you have a right to file for infringement cases as well. Okay. So you don't have to read much from here. There will be full-fledged chapters that are coming. Right now I'm just telling you the meaning. Trademarks are nothing but marks or logos which help the trader distinguish his goods from the other goods. If the trader has over a period of time built reputation, build a brand image, build a sense of quality, quantity, purity, which customers relate, then that mark becomes very valuable. And mark could be not only a mark but could also be a combination of colors, words, etc. For example, Tata, the word Tata is written itself is a trademark. Okay. Then comes copyrights. Now copyrights is related to C square AL. So copyright is related to C square AL. Computer program, your cinematographic activities, for example songs, movie scripts, etc. Dialogues. A is artistic performances, for example a performer singing, a performer making a video, all of this is there. And literary work is writings, so books, novels, everything comes under Copyrights Act. You don't have to do from here, we will have a separate chapter for this, so we will do it from there. Then comes industrial designs. Again, design is about shape, the shape which is appealing to the eye, shape as in patterns which are appealing to the eye. It is generally applied on a product or an article. For example, design of a room, in interior designers can get their designs registered. Then designs of your fashion industry, they can get it registered. Then designs in the jewelry business. So all of this which involves creation of the patterns which are appealing, which are stand out, they are all designs. The designer can get themselves registered. Anyone else using, they can file cases and get legal protection. GI mark is a mark which represents that a particular product is from a particular area. So this mark is given to all the producers of that area. So for example, a GI mark can be given in a location and all the producers, their children can use that mark in addition to their trademark. Now, why is it given to all the producers? Very simple, because over a period of time, the producers of that area, their ancestors have ensured that the quality is maintained from that area. So therefore, this is kind of a mark given to all the producers of that area. If anyone else apart from that area is using this mark, they can file cases that our GI mark has been copied. Then comes trade secrets. Now trade secrets are important. Trade secret is a secret or is a knowledge which is kept hidden from the world. So every business, okay, has some or the other trade secrets. If they have reached the top, they are having something which others don't know. Now trade secrets, for example, how was dairy milk made is not known more than to 5 people. KFC, how is the entire burger made is not known more than 5 people. And once that recipe was lost, if in KFC you see one history, for so many years he couldn't do business. So again, trade secrets are kept hidden, they are not disclosed to anyone. So a trade secret is a method practice, procedure, design, instrument, whatever it is that is not known to others or easily discoverable. An enterprise may give a competitive advantage from the secret business information. A secret can be preserved indefinitely, okay, but you require tremendous amount of secrecy in it, and making it difficult to obtain the information unless inappropriate measures used. So it's very difficult to get that information unless there is a theft of data. So if you go to see in dairy milk, they if you see the photo of dairy milk, they show 2.5 glasses. They don't show 2 glasses because that much amount of milk is used. Milk is used from some country. The cocoa beans is used from some country. So they maintain this kind of secrecy of the entire recipe. Now that we've spoken about the global aspects and the concepts, we'll talk about India and Indian national IPR policy. Now in India, we have a separate act for trademark, copyrights, patent, designs. In addition to this, a national IPR policy has been made. The national IPR policy has come with the concept of Creative India, Innovative India is a tagline. Creative India, Innovative India. It comes under the Department of Industrial Policy and Promotion, Ministry of Commerce, India. So it comes under the Government of India, the DIPP, Department of Industrial Promotion, and which comes under the Ministry of Commerce. Ministry of Commerce. Now, what is the National Intellectual Property Right Policy of India? So again, it was launched or it was adopted in 2016. And it is said that it will be the decade of innovation. Its main policy or tagline is Creative India, Innovative India. The policy covers, now obviously since it is of 2016, it will cover all kinds of intellectual properties, covers all forms of IPs and try to create synergy between them. That means we try to products, on one product you can have a trademark, you can have a copyright, you can have a patent, and you can have a designs. So multiple IPs can be there on one product as well. So it tries to create synergy benefits that nothing about the product can be copied. DIPP is a nodal department of the IPR development in India. The cell for IPR promotion and management, CIPM, under the DIPP is a single point of reference for implementing the policy. So you have your cell for intellectual property promotion and management. So cell for intellectual property promotion and management. It comes under the DPIIT, which is under the Ministry of Commerce. Clear? And it is their role, whose job is to implement this policy. So we saw, when did the policy come into play? 2016. It covers all forms of IP. Then we saw the hierarchy under which department it comes. The DPIT and the CIPM is the single point or single organization that is required to implement the policy. Now again, the Indian policy will obviously be compliant with the WTO agreements and the TRIPS. Now what is the objective of this policy? It's important. Objective is IPR awareness, that create awareness. Generations of IPR should stimulate or create multiple years of IPR should be protected, multiple types of IPR should be there, and it should be going on for generations. A legal framework on guidelines, strong framework should be there. Proper administration of the IPR in India should be done. Commercialization, that is, anyone who is there should be able to commercially get value out of his creations. For example, today if I, in my YouTube video, if I want to use a song, I have to pay the artist. Earlier all this was not there and people were using the artist songs, etc. So we are ensuring that the policy is made in a way that one can get value from their creations. Enforcement and adjudication, that talks about having proper officers, cases, courts in India. Human capital development. Okay, so we should expand the human resource, the number of staff, institutions, capacity for teaching, training, research and skill building in India. So if we go to see the particular website, you can also check up this website, you will come to know. Then the Indian government has provided exclusive rights of intellectual property to safeguard the originality of inventor's work. So very simple, this will be the rule. Then coming that, do ideas get protection? Does an idea get protection? Yes or no? So obviously they say that, listen, even idea is a intellectual property. However, to get protected, you need to do something more, which is more concrete to get protection. So they say the simplest form of intellectual property is a imagination, is an idea. The intellectual property contains rights centered on copyrights, patent, trademark, industrial designs, etc. So intellectual property obviously contains everything. For certification and identification, it serves as a standard authority and certification body. The privileges that a person gets over his work is called as intellectual property rights. They grant a creator a limited time exclusive permission to utilize his work. So they are just giving you general stuff about intellectual property and what powers he will get, which we've already discussed. Positive rights and negative rights. As a result, these changes, the government had decided to create a roadmap for IPRs in India. The intellectual property rights policy puts in place to encourage innovation, enhance the business. Now this is important, you can write. The National Intellectual Property Rights Policy was put in place to encourage innovation, enhance the business climate, make it easier to commercially utilize intellectual property. Next is the policy proclaims that India will be it will be the decade of innovation. These regulations were passed in 2016. It is compliant with WTO and TRIPS legal structure which they have made. It focuses on, IPR policy focuses on improving access to everything, fostering creativity and innovation. The policy outlines 7 goals. Now you have to understand that there are 7 goals of the policy which you can write. First is create awareness building about the IPR, etc. Generations of IPR, to stimulate generations of IPR. I think we've seen that before. Commercialization, enforcement of adjudication, human right development. So there are 7 points which we have seen. And that is it. With this, we've completed the entire chapter, lesson 15. So this is a little theoretical chapter. Okay, no law has come till now, only some kind of basic theory and background of other acts has come. From tomorrow onwards, we will do the 2 important acts as well. Okay, so that is it for today. And before that, Suyash Kapoor, thank you so much. I will definitely come to Kolkata also, but I'm planning maybe Kerala or Coimbatore or Bangalore next. Then soon I will come to Kolkata as well. Okay. So I hope till here it is absolutely clear. I have covered the entire particular chapter. I want you to study all that I have done in company law and all this, because once the video is made private or hidden, then you will not be able to study. The entire objective is that to scare you so that you open your books and study and don't take things for granted. Okay. I hope I am perfectly clear till now. Any doubts, any questions, you all can ask me. I need you all to put in the chat box. So clearly explained. Thank you so much. Lakshmi, most welcome. Yes. Okay, so I have covered everything and all the questions. Sir, come to Coimbatore. We are waiting. Sona, yes, sure. So I'm planning one of these places only. I will see you all soon. Now next, also remember that I will be putting up the schedule also. So right now the schedule is pretty simple. I'm going to cover the entire 40 marks of the new syllabus intellectual property law. Okay. So I just want one request is please share this video with your friends and inform them as well about the lectures. It will help them, especially those who are doing self-study, who need help, etc. And English lectures are specially for the students who prefer to have these lectures in English. They will be able to write it in English, improve their vocabulary as well. So that's it. Just like the video, share the video with your friends, to anyone you think needs help. That's a request to all of you all. That's it. Thank you so much. I will see you all again tomorrow with the next chapter of intellectual property law. Old syllabus students, for you all it is not there so much. It's mostly for the new syllabus students. For old syllabus as well, there will, whenever there is a topic, I will tell in the WhatsApp and the Telegram groups. Thanks a lot, Sona. Thanks, Lakshmi. Thanks, Suyash. Okay. Take care. Bye. Have a great day.